in order to prosecute them in the United States. We are in a total different context. We are not in the administrative context anymore. We are in a criminal context.
So Douglas, since you've last come into the studios, we've talked about the Geneva Court of Appeals and the transferring of former bank employees' data as being illicit. But can we discuss a little bit more where we go from here?
Well, basically, it's the first decision being rendered in Switzerland, so it's very important. And since the two banks did not recourse to the Supreme Court, it is now the final decision for these two particular cases. Now we face another problem. There is about 1,000 decisions rendered in Switzerland by the civil judges forbidding the banks to transfer the data for those who oppose, so it's quite large. Now we have a second problem, is that the IRS, the tax administration in the US, requests mutual assistance in administrative fiscal matters to Switzerland in order for the US to have the data regarding the clients, the taxpayers. Fine with this. The problem is that when the IRS sends this international request according to the treaty between the United States and Switzerland, it comes to the federal tax administration in Switzerland, and this federal tax administration decides to send everything to the United States, including the names and the data of the former employees or third parties who benefit from a decision of the civil judge not to transfer. So we come to this very strange situation when you have about 1,000 decisions all over Switzerland rendered by the civil court saying, no, it's too dangerous for the employees, do not send this data to the United States. And then you have a Swiss administration, federal administration, that says, we don't care because the civil courts are the civil courts, we are administrative, so we just send everything. Of course, that's not coherent at all. So what I did for one of my clients is to have a test case and appeal to the federal administrative courts, which is the highest court in Switzerland, to say, please order the Swiss tax administration to black out the names of the clients who benefit from a civil court order saying that the data should not be transferred. The point of this treaty for assistance is to assist, one country assists, Switzerland assists the United States in order for the United States to tax its citizens, so that taxation can be done. Obviously, the US do not have any interest whatsoever to have the name of the employee or the third party in order to tax its own citizen. Now, if the purpose is actually not to really have the name of the US person, but to have the names of the employees in order to prosecute them in the United States, we are in a total different context. We are not in the administrative context anymore. We are in a criminal context, and that should, in this kind of cases, it should apply the specific criminal assistance between the countries, and criminal assistance will not be granted because what the former employees did was absolutely in no violation of Swiss law, and consequently no data would be transferred. So we have now the situation when you have 1,000 decisions rendered all over Switzerland by civil courts saying, no, don't transfer, it's too dangerous for the employee, and you have an administration, the Swiss tax administration, on request of the US tax administration, say, oh, I can't see any problem, I'll just send everything. That's simply not coherent. Hopefully, within a month or two, we will have a decision by the administrative federal court, the highest court in administration, in administrative law, that will say, come on, let's be coherent. And the US do not need to have the name of the employees in order to tax the citizens.
Absolutely, and it definitely seems like mixed messages there, but what would you say in regards to compensation from the people that were affected by this?
So that's the second step now. because what we obtained so far is the statement that it is illicit. Now the compensation, lawyers' fees, compensation for the tort given like that, because some of these data were sent regarding the decision rendered by the Court of Appeal, one of my clients. There was 1,623 data being sent to the US. You can imagine all the emails, everything that the poor assistant employee sent. So it's really important. She no longer have any future in that kind of profession, so she has to find another job. She was jobless for a while, so you can imagine that there is a definite damage to be compensated besides the lawyer's fees. And that's why we are now before the special court employer-employees dispute in order to collect some compensation for this particular case, more than 500,000 Swiss francs.
And were there any banks that, in your opinion, weren't complying with this or didn't meet up to expectations?
As far as I know, all the banks apply the decision rendered by the Swiss courts. That means that if they are ordered not to transfer, they do not transfer. And we can say that according to the program, you remember there is a program launched by the US, 106 banks joined the program, unilaterally say, oh, I made a mistake, I'm sorry, how much do I owe you? And that's how the US collected $1.3 billion in fines. So it's quite important for the US. Frankly, whether the US do not have a couple of data regarding only 1,000 persons out of 50,000 that were already sent, regarding 50,000 persons or entities already sent, frankly, if they don't have 1,000, they would not care. They collected already $1.3 billion. They have enough information for many to launch prosecution, if they wish so, against many former employees and third party. I don't expect, frankly, that they would insist in having the few data that are missing.
Absolutely. Well, Douglas, thank you so much once again for coming in and sharing your insights.
Thank you very much.
Well, that's all from us once again, but for all the latest Dukascopy updates and interviews, do keep clicking back to Dukascopy TV. Goodbye for now.